free to leave. She is not free to leave. She is not free to leave. I don't know if I called the case, but this is case number 234456901. The people of the state of Michigan versus Michelle Eunice Jackson. Defendant is charged with 1 count of disorderly person. Today is the day set for sentencing. The court has had an opportunity to review the pre-sentence report. With respect to the pre-sentence report itself, are there any additions, deletions, or corrections on behalf of the people?
Judge, there is one minor correction on the face page, only because I just didn't like how it was put onto the report. So the original charge should be count 1, assault aggravated, count 2, assault or assault and battery. The plea agreement was to dismiss count 1, assault aggravated, and to amend count 2 to disorderly conduct. And that's how we received this final charge. And that plea agreement was a global resolution that was made in the Third Circuit Court with another case in that court.
Ms. Stevenson?
Okay, so the comment section of the substance abuse use and treatment section there, I will say it this way. Ms. Jackson reported during her interview that she was trying to stop using cannabis, smoking marijuana and smoking cigarettes. So she didn't say that, she's advised me that she didn't say that she no longer smokes marijuana. She said that she's trying to stop smoking marijuana and stop smoking cigarettes. And also in that same section, Your Honor, she wants the court to know that she did not report that she consumes 2 to 3 shots of alcohol every 2 weeks. She did report that she last consumed alcohol on November 14, 2023. And at that time, she consumed 2 to 3 shots of alcohol. But her alcohol consumption that she reported is occasional use, not that she's drinking 2 to 3 shots of alcohol every 2 to, or every, whatever that every 2 weeks. Hope that made sense.
All right. With respect to sentencing, anything on behalf of the defense? Strike that. I'm sorry. On behalf of the people, I apologize.
It's okay, Judge. Yes. So, Judge, the recommendations from the people, because the original charge was assaultive in nature, the people did recommend a term of probation, 24 weeks of anger management, no contact with the complainant witness, and restitution for any out-of-pocket medical expenses that was paid by Ms. Vincent. Looking at the report, Your Honor, on page 2, it looks like there was a recommendation for probation for a 15-month probation period. So I'm asking the court to adopt that. However, they did recommend 15 weeks of anger management. Like the people said, the recommendation was for 24 weeks because of the underlying charge, Judge. So I'm going to ask the court to actually amend the 15 weeks to 24 weeks. And then Ms. Vincent is in person. She did give a victim statement to the probation department, which is on page 4, Judge. However, she is in person, so I would defer to her if she would like to make a verbal victim impact statement to the court since she is in person today.
Okay. Okay, well, hold on. Okay. All right, well, she already said yes, she would like to.
Okay, first I would like to thank you, Judge, for allowing me to express my feelings on this case. And I'm going to start off with this. I did not agree to her charges to be dropped down. Me and Christine Ritter had a conversation before that court date. And from my assumption, it was supposed to be that the felony charges was going to get dismissed. And the 2 charges that she was being charged as in your court case, she said the lower charges was going to get dismissed and she was going to pursue the count 1 aggravated assault. And the day that the court was, I never was informed about that court case. I was informed about the felony court case. And when I made it over there to their court case, they told me, no, they're in Judge Louise Bryant's court case right now. I said, that's court today? Because they never told me that. So I had to physically run over there to that court. And when I went in there, I kind of didn't understand. I was very confused the day, the judge asked me if I agreed to the charges being dropped. I was like, yeah, because I'm thinking I'm agreeing to the original conversation that me and Christine Ritter had, which was drop, the lower charge assault and keep the highest assault. She was charged with 2 counts. I'm thinking she's gonna get charged with count 1 and the other assault was gonna be dropped. That's not the case. They actually dropped it down to
Ma'am?
this one.
Yes, I'm hating that I'm interrupting these victim impact statements today. Okay, I'm hating this because I'm confused. Okay, go ahead. Maybe it's going somewhere that's going to help me. Maybe it's going somewhere that's going to help me.
Statement, I just wanted to say that because new issues have arisen. So I'm gonna go ahead and say my victim statement, but this has to be addressed. It's not that she damaged my shoulder by the torn rotator's cuff, it's more damage that's being done now due to that. And so a disorderly conduct charge is not appropriate as far as I'm concerned. That's not fair to me. She did bodily harm to me. Disorderly conduct is more like if you're being in public, intoxication in public or something like that. It's not the seriousness of my injury should be also the seriousness of the crime. Now, back in March, this is me going to my victim statement. Back in March, it started off in the morning, about maybe 9:30ish, if I can remember, 10 o'clock. The garbage ran. I walked outside my house to plug in the garbage cans. I saw Michelle and her sister Monique outside. I guess Monique carried the garbage cans in. I turned around, I opened up my gate and I put my garbage can in. I don't know what they were doing. They think that I always watch my cameras. That's not the case. So I went in the house, I washed my hands, I changed to my gym shoes. I asked my fiance, you need something from the gas station? I'm going to walk to the gas station. When I proceeded to walk outside to the gas station, I didn't know at the time, but Michelle Jackson was sitting in her car. Now, keep in mind, she has tinted windows. I pay no attention to them. I don't know where her other sister was, so it looks like nobody was outside. As I'm proceeding to walk to the gas station, she decides to back out her driveway. That's when I realized when she's sitting in her car, back out her driveway and pass me up and go in the direction of the gas station. When I got to the gas station, as walking up to the gas station, she was already parked at the gas station. She was not at a pump or anything, and she had not gotten out of her car yet. She waited for me to go through the doors of the gas station. When I went in the gas station, she came right in, got behind me and started mouthing off at me, threatening me, calling me obscene names. She didn't want to fuck me up, put her hands all in my face, all of that. And so, my reaction, because she was all in my personal space, is I proceeded to put my fingers back in her face too. I said, okay, at this point, I'm gonna call 911. I turned my back to her when I called 911, and she continued on threatening me. I don't give a fuck, this, that, and the other, about me. And some of that should have been called 911 reporting. All I know is while my back was turned, she pushed me enough for me to fall over, and I hit something. That's what damaged my shoulder. I hit something. I don't know if it was the counter or the shelves, but I hit something. And I fell over, and she was like, oh, you can't fight me. And she walked out the gas station, and I was really angry. And I'm gonna tell you right now, in the neighborhood, and this is her too, she thinks that a strong person is a bully that likes to fight, can't settle an argument intelligently. But I'm gonna tell you, I'm here to tell you, a strong person is who have endurance. Because I have been dealing with a lot and I don't have time. My grandmother a long time ago told me, before she passed off, that in order to keep a person down, you must stay down with them. I'm not trying to stay down with them. I'm trying to elevate. I'm actually decided to move from over there because it's constant. This has been going on for a very long time since they moved over there. It's just been issues after issues with her. Issues with her pulling up in my driveway and just sitting there. This is after conflict arises with our families, that we don't talk, we don't speak, we don't have no association with each other. She would just sit there. That was the issue. Then there was an issue with them pulling up all the way to my driveway, damaging my grass. I've had my property damaged. I've had my cars damaged in the past from her. Tire slashed, scratched up. constant. I've reported all this to the police department. They don't do anything. And then eventually somebody told me in the neighborhood, they have police in their family. So that's why I see that nothing ever happens with them. And her ego has grown to the point where she sat in that driveway and she premeditated this attack, of course, on me. She sat there, she thought about it. She planned to do it because she saw I was going and she followed me. I'm not gonna say followed me. She made it to the gas station before I did. When I go, because I don't have a vehicle right now, thanks to them, I walk to the gas station. There's nothing else around in our neighborhood but the gas station. It's around the corner. She knew I was going to the gas station and she decided to beat me there and pass me. She was in a car. So when I got there, she was already in the parking lot. So she took time out to think about that attack. She attacked me and then she left. Again, this charge of disorderly conduct, I hope that you can change that. I don't think it's fair when I have injuries and injuries that I have to deal with for the rest of my life. I have a torn rotator cuff. I went to therapy, 3 to 4 different therapy appointments. They told me the only way to cure it is to have surgery, but because I am a cigarette smoker and of my age, I'll be 55 this year, this year, and I want peace in my life, that they don't recommend me have surgery. So I decided to go the physical therapy route, and the physical therapy seemed to help. But since then, I've had some more pain. And I said, what's going on? It was trickling down my arms. I was like, what's going on about this? Went back to the doctor, they took x-rays and they said, oh, arthritis set in. And so what has happened is the rotator's cuff, when you have that injury, the cuff is not covering your bone anymore. Your bones are rubbing together. The friction has created the arthritis in my arm. And so now I'm going through arthritis. So every other day I put like a lidocaine patch on my arm. I use a cream and I take medications. And I also been in contact with Ms. McCall, the probation officer, and she told me to email her all this information. And that's what is coming to the restitution part, because I had to go back to the hospital. Now, back when the original incident happened, I had insurance. I don't have insurance anymore. Not that insurance, so I'm not insured. I had to pay to go to the hospital. They actually send me bills. The hospitals themselves have kind of like, I don't know, they kind of like custom the bill down for me because I'm not insured, but I do still have a balance, and I sent her all that information. And I also have my hospital paperwork from that visit with me today. And so I'm just here to humbly ask you, because I listened to you and you said that, you know, with talking to the last person, that you are a judge of honor, that you don't have anything to do with that. And I'm trusting that you would make the right decision today, because I just feel like the reason all this is going on is because nothing's ever happened to her in the first place. It's given her a big chip on her shoulder. I don't know, she's a different person right now. That's not who she really is. The light voice, talking, you know, softly and all, no, that's not her. She's embroiled with that gangster lifestyle. She thinks it's cute, you know, coming outside, being out at night, you know, trying to be the baddest one. I don't have time for that. I don't care about that stuff. Neither do I care about what people think, because now, you know, the neighborhood thinks she's beat me down, all that. No, it's not that. And I'm not scared of her either. I'm going to say that. The only reason I chose not to fight her back is because they have police in their family in the past. When I defend myself against any of them, I am the person that gets arrested and go to jail with no questions asked, never no charges has stuck, because when they get to court in front of a judge such as yourself, they see it's no relevancy and they dismiss the case. But it's just a problem of going through that, being locked up for 3 days in a Detroit Detention Center, paying an attorney money, you know, going through all this stuff. I had pets at my house. This is back before my fiance moved in with me. I was worried about my house, and I forgot to mention 2 summers ago, my front door got set on fire, and I know that she has something to do with that as well. 2 summers ago, there was an issue where she had all these people come on the street, and my children was up. They told me about it the next day that they still on the street. They was like sitting outside watching my house. Like, it's been a whole lot of stuff that has happened with this girl right here. And so I feel like at some point she needs to step up and be responsible for what she's done to me. She has not been shown any, she hasn't showed any type of remorse at all. She hasn't apologized. you know, and those charges was dropped down to disorderly conduct, it's like all the care is going towards her. She's not the victim. She caused this to happen. And then they're being so careful about her, like she's delicate when she's not. So I would just like you to reconsider that because, I originally wanted her to be in jail, but they told me that, you know, no, there's no jail time for this. This is a misdemeanor. They also told me that disorderly conduct is the same sentencing as the aggravated assault. So then why drop the charges down to disorderly conduct? Why not keep aggravated assault on her case? Because she assaulted me. That's what she did, and she caused injury to me. I've never heard of anybody getting injured from somebody from a disorderly conduct case. And so that's what I came to say.
And Judge, I'm sorry.
No, go ahead. It's still the people.
Thank you, Judge. And I just want to clarify a few things, Judge, because I see the way these sentences are going today. Just to clarify, with respect to this case, like I said, Judge, this was a global resolution. There was a felony case in Frank Murphy, and the felony trial APA who handled that case had conversations and negotiation conversations that I wasn't privy to with Ms. Vincent. And Ms. Vincent spoke with him and also spoke with my supervisor regarding this case and about how the plea negotiation will go as far as this case. And just to clarify, Judge, there wasn't any conversations as far as the disorderly person being the same as an aggravated assault. The conversations were that the people would have the recommendations similar to a charge that was assaultive, as the people did clarify in their sentencing record. So I just want to make that to the judge.
Okay. Ms. Stevenson, anything on behalf of the defense? No, ma'am. No, ma'am. Ms. Stevenson, anything on behalf of the defense?
Yes, thank you, Your Honor. So I guess I would want to say first that I looked and I may have overlooked it, but I didn't see the plea recommendation that the people have referenced this morning, that for the term of probation and the restitution. And so I did not advise my client with regard to that. But I did have an opportunity to talk with Ms. Jackson. I had an opportunity to prepare this matter for trial, not being aware at that time that the felony matter was even outstanding and really not even taking it into consideration. And I would say this, Your Honor, just if I know anything, well, I'll start it like this. The incident to which Ms. Jackson has pled guilty did happen at a place where video surveillance was available. So in preparation for, attempting to meet their burden of proof, the people, I believe in this case, as well as in the felony case, took that video evidence into consideration prior to moving toward attempting a global resolution. That is absolutely significant, Your Honor, because I just don't think that if this prosecutor on this docket believed that the global resolution was outside, that it just was not a just resolution, that regardless of what the felony prosecutor wanted to do, if this prosecutor, I believe.
Can I interrupt you? I'm sorry. I'm doing a lot of interrupting today, it looks like, but I mean, your client is literally sitting in the dark and she got her phone up, and I'm getting offended, and I want her to stop. Like, I want her to stop. So she's sitting in the dark. She's on her phone. Ma'am, don't do that to me. I don't know who you think. Let me tell you something. You got the right one today. You have the right one today. So what we can do is adjourn and everybody come in person. That's what we can do. Yeah, because don't do that. Don't do that. Maybe you need to go talk to your client in the breakout room, because don't do that. Because every day that I come on this docket, Lanice Bryant is in control. Lanice Bryant is in charge. I don't care who your cousin is, your brother is, your uncle is, your daddy is. I don't care. You could be the daughter of Barack Obama. I don't care. You in my courtroom.
So, Judge,
Now roll your eyes at me again. Roll your neck at me again. And it's going to be different. What I need is for her to find a way to face the sun so that I can see her face.
okay.
She's making facial expressions. She's on her phone. And she's not being appropriate to this court.
Okay.
So go in the breakout room, get your client together, and come back out and finish making your statement.
Okay. Thank you so much, Your Honor.
You're so welcome. We're back on the record with case number 234456901. Okay, Ms. Stevenson, you may continue.
Thank you so much, Your Honor. We thank the court for an opportunity to just kind of let things calm down a little bit. So I guess my first observation, Your Honor, and I have had the opportunity, and Ms. Jackson has had the opportunity here with Ms. Vincent has had to say about the incident, but I just don't believe, Your Honor, that regardless of what was happening with the felony case, if the events had transpired in a way more consistent after with what the victim has testified to, I don't know that the people would have made themselves the people in this courtroom would have made themselves party to the global resolution, Your Honor, landing us where we are today. I do believe that, you know, review of the video surveillance by the people in consultation with the victim, Your Honor, led the people to make the offer that they made to not only reduce or dismiss the more serious misdemeanor charges, Your Honor, but to dismiss the felony charge as well. As Ms. Vincent has alluded to, there has been ongoing conflict between these parties, Your Honor. Much of that conflict, Your Honor, resulting in Ms. Vincent receiving, you know, some having been on the receiving end of police contact, Judge. So Ms. Jackson is here to accept responsibility, as she stated in her description of the offense, for being in a public place, at a gas station, getting into this loud argument with the complainant, and she's indicated that that's where it landed. I hate these neighborhood dispute cases, Judge, because it's so hard to just muddle my way as defense counsel through them. But we are where we are, and where we are right now is at disorderly conduct. And that Ms. Jackson has admitted to behavior which is consistent with that charge. And the incident does not happen in a vacuum. Ms. Jackson has been you know, inordinately, in terms of where we are in court, animated, and I believe she's adjusted her behavior. That behavior that you know was not directed at the court, is directed at the volatile situation that we hope has come to an end. I just hope that these people are going to be able to if they're going to live around each other, that they'll be able to live around each other peacefully. But Ms. Jackson, at this point, Your Honor, does stand convicted of disorderly conduct. And that is after the felony prosecutor and the misdemeanor prosecutor had an opportunity to look at their cases and make a decision as to what the evidence would allow them to be able to prove beyond a reasonable doubt. And they've landed at disorderly conduct. That's behavior that Ms. Jackson has admitted to. And I haven't, again, I don't know if I overlooked it or what, but I didn't see a plea agreement that talked about restitution. So I didn't talk to my client about that, Your Honor, but Ms. Vincent would not be without remedy. She would have an opportunity to present her case in civil proceedings and try at that point to use whatever evidence is available to her to substantiate her claim for restitution. But Ms. Jackson has pled guilty to being in a loud argument with Ms. Vincent, and I believe that the people, based upon their global resolution, agree with that. So I would ask the court to not do restitution at this time, Your Honor. I would ask the court to forgive Ms. Jackson for her behavior this morning, which was earlier this morning, which was really inappropriate. Her frustration is not directed at this court. That frustration is directed at this entire situation. And I think that everybody, including myself, would be able to benefit from some anger management. So I don't think that's going to be harmful to Ms. Jackson in any way. But I would just ask that the sentence, Your Honor, be more in line with the crime to which Ms. Jackson has admitted responsibility. She is working on taking care of these outstanding warrants. I want to address the elephant in the room, that what I believe to be an elephant in the room, that Ms. Jackson doesn't have a driver's license, but the evidence does show that she drove. So the probation department's recommendation that she take the driver improvement class, not drive without a license, that she get a driver's license. I mean, I don't know about the court ordering her to get a driver's license, but certainly we have no objection to any prohibition against driving without a driver's license. And once Ms. Jackson is able to take care of these monetary obligations in Farmington, I think that she'll be on her way. I think all that kind of stems from the same situation, that she'll be able to move toward getting a license. So certainly no driving without a license. I don't know about getting a driver's license. I would ask the court not to do any restitution at this time. Absolutely no objection to no contact between the parties. But I just ask that the sentence follow the charge.
Would Ms. Jackson like to make a statement on her own behalf? Somebody say something. Ms. Stevenson, I'm asking you, would Ms. Jackson like to make a statement on her own behalf?
I apologize for that, Your Honor. I believe that I didn't see it was that she was muted. I believe that Ms. Jackson would like to address the court. Ms. Jackson, if you could unmute at this time.
Good morning.
Good morning. And would you like to make a statement at this time, Ms. Jackson?
Yes, I will.
Okay.
Well, I apologize, Judge Bryant. I didn't mean to make you feel disrespected in any way. Me rolling my eyes or anything, I didn't mean for you to feel disrespected. On behalf of my case, Miss Darla, me and Miss Darla, she said we had a back and forth for a long period of time, but it wasn't actually me and Miss Darla having a back and forth. It was her and one of my siblings that she had a back and forth with. The only reason I went up to the gas station that day is because my youngest sibling had already gone to the gas station. Jamal, which is the one that she said that was Monique, the one that she said that was outside with me, but we were never outside together. I was already sitting in my car that day, and Monique just happened to come outside and walk to the gas station. Next thing I know, Miss Darla was walking to the gas station. Now they're the two that been having this ongoing battle back and forth. So I knew that it was going to be a problem at that gas station with them both being there. I only went to the gas station to get Monique in the car, and I wanted to talk to Darla that day. I wanted to talk to her to try to stop some of the drama that's been going on back and forth. That's it. Talking with her did not go well. She, I want to say she's not easy to talk to. So we started arguing. me putting my hands on somebody, I'm in school trying to be a nurse. I also work two jobs and take care of another person for the state of Michigan. I don't have time to be out here catching cases or doing anything. Yes, I'm 40 years old. This the first time I ever been in any trouble like this. Yes, I do have tickets in Farmington that I need to take care of, but just getting in trouble and arguing and fighting with somebody out on the street, I do not do at all, period. I just wish this never even escalated to this point to where I would have to go through this, but I did. Very, very much so a learning experience. But I never had no bad intentions toward Miss Darla. I always thought she had I know she had an issue with my family. But other than that, I mind my business. The only time she see me is when I'm going in and out the house to work, to school, back. That's the only time she really has seen me. The most she ever talked to me is in the gas station that day. So her stating that it's been an ongoing and that I got tint on my car windows, my car is a fishbowl, Your Honor. You can see right through it. She knew I was sitting there, all that. It's not a car that has tinted windows, period. So I don't know why she said that, but whatever. I don't. All I really want is peace. That's it. We stay right across the street from each other. When I walk on my porch, her motion lights to her camera go off. She's watching. She's doing. She even will step out soon as I step out sometimes. So I just want peace. I don't want no more drama after this. This has been life-changing for me to have to go through this. I've never been in court so much in my life. So I just want peace after this. And not only have it's been me and my family, it's all the families around us. All the family down this block has issues and court issues with Miss Darla. But nobody is catching on to who the problem is. I just want peace after this. And that's all I have to say.
That's so much.
Ms. Ritter, can you address Ms. Stevenson's issue about the restitution? She said she didn't that your plea agreement did not include restitution.
Well, Judge, it was a recommendation based off of the information received from Ms. Benson. I don't have any receipts. I know that the restitution.
I'm saying, address to me why I would order restitution on a disorderly disturbance case, and Ms. Stevenson said it wasn't a part of the proceeding. I mean, it wasn't a part of the agreement.
Judge, just stated in the sentencing, there was a recommendation that was similar to the underlying assaultive charge in nature. So that's why the people recommended the restitution, if there was any, for any out-of-pocket medical expenses arising from the underlying charge.
But it's not allowed unless it's an agreement, isn't it? So that is how my question is more to what authority does this court have to order restitution on a disorderly disturbance case unless it was a part of a plea agreement? For a disorderly disturbance case, it's disorderly disturbance. I mean, so Ms. Stevenson is saying she didn't agree to any restitution as a part of this plea.
I understand, Judge, what the court and what Ms. Stevenson is saying. Again, Judge, that was part of the plea agreement for the recommendations.
I still don't understand what you're saying. You keep saying that was a part of the plea agreement, but it wasn't. You saying that's just the people's recommendation.
Correct, Judge.
Oh, okay. Okay, so I'm ready to impose sentence. Mr. Flanagan, I do apologize because of course you're aware that I am away from,
Excuse me, Judge, I don't want to interrupt, but
no, ma'am, but you are, and this is inappropriate. Victims give victim impact statements, and that's it, and that's all. That's
she
it.
lied. I have a video that
Ma'am, I would hate it. I would hate this to turn a different way. Victims give victim impact statements, and that's it. Now you all are gonna stop. You're not gonna hijack my courtroom ever, ever. Except for the question that I asked at the very beginning, I let you make a statement. It's one of the longest victim impact statements that's been made on the record. And I let you make it because victims have a right to give a victim impact statement. And really, the giving of the victim impact statement in this situation was Grace, because she is charged with disorderly disturbance. According to the Victims' Rights Act, there is no victim on the disorderly disturbance case. But I allowed you to make a victim impact statement, and then you're going to interrupt and just hijack my courtroom. This is not appropriate. It's not appropriate. It's just not appropriate. Now I'm ready to impose sentence. Mr. Flanagan, I don't have the form with me, so it may not just be in the order that it normally would be in. All right, so let me say, you know, again, and everyone knows I hate neighbor disputes, because I mean, when you go home, you're supposed to, that's, you know, when you have a hard day at work, when you meet something on the street, you know, strangers, when you encounter situations out and about, when you go home, that's supposed to be your place of rest. That's why you know, domestic violence cases are so serious, and you know, a child abuse case. I mean, children, when they go home, they should be safe. People in relationships, when I go home, I should be safe. And then, but neighbor disputes, they, you know, sometimes they baffle me, because you never have to speak to your neighbor. Like, you never have to ever speak to your neighbor. Like, you literally never have to speak to your neighbor. You can pull in your driveway, or, you know, depending on what side of town you live on, because some neighborhoods, some people don't have driveways. And then you just pull in front of your house and you park, and everybody should understand, like on the streets where there are no driveways, that you're not entitled to the parking space in front of your house. You just are not entitled to the parking space in front of your house. So you have to just park where you can park. And so when you have a neighbor dispute, you know, I wish that mediation could work, because it's better for neighbors who have to live amongst each other to work things out, right? That's what's better. But obviously that doesn't occur in many situations, because of this docket. I've listened to everyone today. I've listened, despite the fact that it is something in the atmosphere that everybody that has come on here almost has been rude and disrespectful to me. And at a certain point, I'm 57 years old. So yeah, I'm 57 years old. And what I didn't do is go to law school, accept an appointment from Governor Granholm, run for election 2 times. I didn't do that and say, oh, because I love being abused and I love people to disrespect me. And I just want to get up every morning and go to a place where I'm abused and disrespected and mistreated. So it's just amazing to me. Many times, this is my first opportunity to even speak with the people involved in the case. Yet, I'm the person that, you know, people take their frustrations out on. And I guess that is a part of the job. And I've listened to both of you, and both of you have been disrespectful today. I don't know, Ms. Stevenson, the defense made comments about not believing that the people would participate in this type of resolution if the evidence didn't show what Ms. Vincent says. I don't know that. I don't know what the people's motives are. I don't know why the people make global resolutions. Many times cases are settled and I disagree. I disagree with the resolution, but that's not my business. That's somebody else's business. I don't know who Ms. Ritter's supervisor knows. That's not my business. I didn't see the video because it was a plea. That's not my business. I don't know. Nobody has shown me the video at this sentencing hearing. So I don't know what the video shows. I don't know who is telling the truth about the video, right? But what I know is that Ms. Jackson stands convicted of disorderly disturbance as a global resolution to cases that started out with felony charges and with a misdemeanor assault aggravated and misdemeanor assault and battery. That's the only thing I know. And then I know that she doesn't have any prior criminal history other than these cases where she keeps allegedly, because I don't know if they're post-conviction or pre-conviction, driving without licenses. All right, so somebody is not being honest because the two stories are opposite. That means when two stories are opposite, that means somebody is not being honest. Well, I can't figure out who's not being honest. This isn't a trial. We're not, ma'am, I need you to stop it. Now, the fact that you're still standing at the podium also.
They have not shown any evidence. No, I'm not gonna keep sitting.
Let me say this, officer, take her into custody. So we're gonna take her into custody right now. We're gonna take her in. Officer,
here. I don't have to stay here. I don't.
She is not free to leave. She is not free to leave. She is not free to leave. I am gonna hold her in contempt of court for disrupting and interrupting my proceedings. I am holding you in contempt of court for disrupting and interrupting my proceedings. She is going to have a seat in the jury box and she is not free to leave. She is not free to leave.
I need my jacket.
No, you don't. She's going to sit in the jury box and she is not free to leave. And if you disrupt my proceedings again, the sentence for the contempt is going to include Wayne County Jail. Do not disrupt my proceedings. Okay, now, as I was saying, someone is not being honest, and I don't know who it is. But Ms. Jackson, I can tell you get worked up too. So Ms. Vincent gets all worked up and is rude and disrespectful, and then so are you. And that's probably why you all can't resolve whatever the neighborhood conflict is. I asked you to put your phone down, you rolled your eyes at me. I asked you to turn on to face the sun, or let's try to get, because you're in the dark, you was rolling your neck at me. But then when everybody want to talk to me, when you want me to listen to you, when you want me to absorb everything you're saying, then you're nice and respectful. When I'm saying something that you don't like, you're rude and disrespectful. So help me, unpack that. I'm sure when you were in the gas station, nobody was talking nice and calm, like either one of you were talking when you were talking to me uninterrupted. And so your body language says that I don't know why the people gave the resolution that they gave. I don't know. I have no idea why they dismissed the felony cases, why they dismiss it could be for a number of reasons, and it could be, if the witness is yelling at you and being rude and disrespectful. But I don't know what goes into their decision making. That's not for me to know. But Ms. Jackson, you came to my courtroom on the day of your sentencing and you were rude and disrespectful. And then everybody is expecting, you expect me to give, the probationary sentence. And let me say this, I learned, or I was very, I watch a lot of court TV, and a lot of times it's because I'm trying to learn things. I'm trying to learn certain things when I'm watching court TV, right? And there was a judge the other day that got attacked. She was getting ready to impose sentence, and the defendant leapt all the way across the thing and leapt all the way across the bench, right? And then he tackled her down. They since charged the young man with attempted murder. And if we were in person, if everybody was in person and not just Ms. Benson, I could see how this situation would have got out of control, and my courtroom would probably be full right now with 2, 3, 4, and 5 officers, because there's not going to ever be a day. There's never going to be a day when I'm going to come to work and not be in charge of my courtroom. And you all have been disrespectful and unruly. But what I learned from the judge, she went to the hospital. The young man almost looked like he was about broke her neck. She was probably very fortunate that when he landed on her, he didn't break her neck. But she came back 3 or 4 days later. And she was careful to make sure that everyone knew and that the record was clear that the sentence that she was getting ready to impose was the same sentence that she was going to impose before that young man attacked her. Now, I use the sentencing and what the victim says and what the defendant says to help me fashion a sentence that is appropriate. When probation gives me a pre-sentence report, it is a recommendation. It is a recommendation. When I hear from the victim, I take that into consideration. I took everything that Ms. Benson said into consideration. Every single solitary thing. And I'm thinking, this is something, and Ms. Jackson must be a pickle. Until I told Ms. Benson to stop talking because her term was over. And then, like night and day, Jekyll and Hyde, that switch was flipped. And had I been in person, it probably would have been a different situation. And then she didn't do it one time, she did it twice. So now all of a sudden I'm saying, uh-oh, maybe Ms. Jackson, when she gave her calm statement. Now, Ms. Jackson gave a calm statement after she had to be sent to the breakout room. She had to be admonished by the court. The problem with this neighborhood dispute, because both of you blaming the other person. This family, they family, this. Well, let me give you both of you a news flash. It's both of y'all. It's everybody involved in the situation. It's nobody has a calm mind to try to resolve conflict. It didn't even make sense that Ms. Jackson said she went to that gas station, excuse me. She went to the gas station thinking that she wanted to talk to Ms. Benson about, the neighborhood. Don't come up to no gas station talking to me while I'm in line to get my items. That didn't even make sense. What made sense is that she saw whoever else she said was walking to that gas station. And she went to the gas station to confront Ms. Benson. you know, I don't need help doing my job. So sometimes, you know, when people agree with me, they you know, they try to be the amen corner, they shaking their head and all of this, which is not appropriate in court. But as soon as I say something then that they don't agree with, that now you're rolling your eyes and blurting out in my courtroom like we at the zoo. Well, ma'am, we're not at the zoo. And Judge Bryant is presiding. And if Ms. Vinson wanted to preside, Ms. Vinson should have done the things necessary to preside. If Ms. Jackson wanted to preside, then Ms. Jackson should have done the things necessary to preside. You both have been unruly. So I don't know who's telling the truth. But I'm going to impose this following sentence. And again, what's going to happen is that people are going to stop bringing the prosecutor problems to me. I don't work for the prosecutor. I am a part of the judicial branch of government. If there's any person participating in these proceedings who do not know the separation of the branches of government, there is the legislative branch of government, there is the executive branch of government, and there is the judicial branch of government. And I am a part of the judicial branch of government. I don't work for Kim Worthy, and she does not work for me. Her attorneys do not work for me. I don't make any decisions about who's going to be charged, how they're going to be charged, and when they're going to be charged. I don't make any decisions about what the final charges are going to be unless I am serving in the capacity as the trier of fact. Unless I have ruled on a motion. So the displaced anger towards me, because the charges have been lowered, because we've gone from felonies and 1 year misdemeanors down to a disorderly conduct, that is not for the court. That's not my business. That's not my purview. I am going to impose the following sentence. There is a recommendation for 15 months probation, and I'm going to accept the recommendation, but let me tell you something, Ms. Jackson. We don't need angry nurses that's arguing and going up to gas stations and confronting neighbors. And being a nurse is a noble profession. The families that have to deal with nurses, the patients that have to deal with nurses, they're in a situation where they need people that have compassion. They need people that are able to help the family. I just lost a dear friend on yesterday, and she had some of the best nurses that I've ever met in my entire life. And I would be shocked if any of them engaged in the behavior you have engaged in my courtroom today, in the behavior that you're accused of engaging in at the gas station. So we're going to have to change some things. Court is going to set the probation for 15 months. And of course, if you violate the probation and I revoke your probation at some point, just please remember this. Probation is the alternative to jail. Jail is the alternative to probation. I'm currently giving you the alternative to jail. That's probation. If you don't do the probation, jail is the alternative to the probation. All right, Ms. Jackson, we are going to mail a copy of this order to the Thornton Street address. Probation is going to contact you at the phone number ending in 2665. You're all set. Have a great day. Stay safe. I need Ms. Vincent at the podium. Ms. Vincent, I don't know if you've ever heard the words direct contempt. but I've held you in direct contempt of this court. You have been no, ma'am, absolutely no, ma'am.
Okay. I'm sorry. I
And
apologize.
you keep on talking. You just keep talking. I mean, literally, you keep on talking. I have held you in direct contempt. You have disrupted my proceedings on 2 occasions. Not only did you disrupt the proceedings, when I asked you to stop, you kept going. You overtalked me. You were going to say what you were going to say, regardless of what I said. That is rude. It is disrespectful. And it is definitely contemptuous. Direct contempt means that you have committed contempt of court in the presence of the court and while court is in session. In case you're not aware, that is punishable by up to 93 days in the Wayne County Jail and up to $500 in fines plus costs, just like what Ms. Jackson was charged with. I don't know what's the situation or why your emotions are that high. And it most certainly would be a shame for Ms. Jackson to not go to jail for what she did to you, but for you to go to jail for what you did to me. Ma'am, if you ever show up in my courtroom ever again, you need to be appropriate. You need to be respectful, because I will lock you up. I will lock you up. So don't do that. I don't even understand it. And I kept asking you to be quiet. And you kept talking over me after I listened to you. After I let you say whatever you wanted to say. After I didn't interrupt you and say your victim impact statement is running too long. Ma'am, I let you talk. And then you just talked all over me and ran all over me. And then, but you wanted me to believe in that same way. You wanted me to believe that at the station, you were calm. You wanted me to believe that you're 55 years old or you're getting ready to be 55 and you don't have time for this. That's what you wanted me to believe. Now, it's hard for me to believe that when you combative and aggressive to the court. And we're literally live on YouTube and literally a multitude of witnesses. My officer is right there. My court clerk is right there. The attorneys are right here. I mean, you literally have a multitude of witnesses, and then you still are combative with the court. But you want me to believe that you were not combative with Ms. Jackson. You want me to believe that it was all Ms. Jackson. I'm going to, with respect to the contempt of court for Ms. Vincent, I'm going to go ahead and hold in abeyance 5 days in the Wayne County Jail. I'm going to hold it in abeyance. So let's be clear. She is in contempt of court. Court is going to hold in abeyance the 5 days in the Wayne County Jail that I would have given her. She's always, as a complaining witness, of course, free to attend any court proceedings. But ma'am, if you attend any court proceedings and you interrupt my proceedings, I'm going to take those 5 days out of abeyance. And you're going to go to jail for 5 days. Am I clear?
Yes, Your Honor.
Okay. You may.
Okay. I apologize. The frustration was not with you. And I know that I had a chance to make my victim impact statement, but she just lied again. And I didn't know that you
I'm not
never
gonna
saw.
go over that. I'm not gonna go over that, ma'am. Victim impact statement is what it is. You make a statement and then you're done. That's it. That's all. It's nothing else. You don't get to rebut what the defendant says. This is her case. She is the defendant. I'm not going to go back over that with you. And then you said it wasn't, your frustration wasn't directed at me. Oh, yes, it was. Yes, it was. You said you ain't listening to my evidence. You ain't doing this. But yes, it was directed directly, ma'am. It was directed directly to me. That's like me yelling at my kids and whooping my kids, or whipping down my kids and then saying, well, I'm not mad at y'all, I'm mad at your daddy. Well, then why you in here talking to me? That's what I would say if I was the child. Then why you yelling at me? Then why you raising your voice at me? Then why don't you stop talking when I'm saying stop talking? Okay, I accept your apology. I'm going to not impose the 5 days today. I'm going to hold the 5 days in abeyance. And if you choose to come back, you can. If you don't, you don't have to. And then any other issues with respect to the case and the charging, you can take those up with the prosecutor's office. Have a great day and stay safe. Have a great day and stay safe. Have a great day and stay safe. Officers, we're all set. And y'all need to mute the courtroom, because if she says something going out, she's gonna get those 5 days. I'm ready on Boykin.